Hello everyone, this is Samuel Waswakirunda presenting a topic of managing directors of a GmbH in German corporate law. Managing directors of a GmbH in German corporate law. For starters, who is a managing director? A managing director is a person appointed in a top position of a GmbH to learn the daily expert business of a GmbH. Is a person appointed in a position where is learning the daily expert business of a GmbH. However, it should be noted that a managing director, or there can be one or more managing directors appointed in learning the daily business of a GmbH. So, a managing director must be a natural person, to be appointed in the position of a managing director. So it cannot be any of the other aspect of appointment other than a natural person. As we all know that there are cases where we have artificial persons, for example, a company which is recognized as an artificial person. So a GmbH in this essence, it cannot be appointed as a managing director. So a managing director must be a natural person. Another aspect is that a managing director must have any criminal record, must not have any criminal record or any criminal conviction, at least for the period of 5 years, or he must not have any judgment restricting him to hold any position of any nature. Also must not have an administrative order restricting him to hold any position of any nature. So must be free from any restriction of any nature. A managing director, when it comes to Germany, it not necessarily need to strictly be a German national. So a managing director can either be a German national or a foreign national, or appointed from other countries other than German. However, for practical consideration, some writers say or suggests that it is practically should be considered that a managing director must be available where the daily business of a GmbH is run to prevent to prevent cases where there is urgent requirement of a managing director physically where the business is run to exercise or to bind the company's actions. So it is a practical consideration that it must be within German. However, also it is considered that in cases where a managing director is appointed from abroad, some writers suggest that a managing director of that nature must have a travel permit. Yeah, it must have a travel permit to always be available in the inland or in German, where whenever is needed physically. So it is that nature of managing director that we should always need to consider in appointing a managing director. However, we should also not get limited to a managing only one managing director. It should be considered that any GmbH must have at least one managing director. So it means that he or she might be appointed as one, or might be appointed. Many managing directors can be appointed. Another important aspect of looking at the aspect of managing director is the fact that for establishment of a GmbH, there are two crucial elements or structures of a GmbH. One, which is a managing director, and also shareholders. So the point of a managing director towards a GmbH, it is a very central point. So it is a very central. So a GmbH cannot do without a managing director, and that means that a managing director can be appointed during the registration of a GmbH, or could be appointed consequently after the registration of a GmbH by means of a shareholders resolution. So that is important to note. However, in cases where we have a supervisory board, to avoid conflicts in office, a supervisory board member is not supposed to be appointed as a managing director. So it should be considered that a supervisory board member cannot be appointed as a managing director. However, a shareholder can be appointed as a managing director. A GmbH, now, after appointment of a managing director, it means that in all cases, a managing director will be representing a GmbH in all cases, be it judicial, be it non-judicial matters. So in cases where a GmbH sues, a GmbH sue through a managing director, or a managing director sue on behalf of a GmbH. And in cases where a GmbH has been sued, a managing director defends or represent a GmbH in such matters. Also, a managing director, if we are to continue to appoint of exercising statutory duties, a managing director must ensure that a GmbH fulfills all statutory requirements of learning, of the daily learning of the GmbH. So it is the managing director has to make sure that a GmbH complies with all legal requirements. So this means that a managing director is now the boss of the GmbH. So he manages all aspects of the GmbH, and he does all what is required to see that the GmbH learn its business efficiently by doing all what is required in managing the daily business of a GmbH. So this means that having appointed the managing director, we should also look at the point of appointment. as earlier on saying that a managing director can be appointed during the registration of a GmbH or after the registration by way of shareholders resolution. So shareholders have the powers also to revoke the managing director. So in cases where let's say a managing director breaches the contract, shareholders have the powers to revoke the contract by either by cause or by without a cause. So that is a good point to note. So there is another point where we have to consider that, as we said, that there might be more managing directors of a GmbH. So in such cases where managing directors or where a GmbH enters into contracts with third parties, all managing directors must be present or must authenticate or must sign such contracts. All of them must sign the contracts on behalf of the GmbH, all of them. So that is where we have more than one managing director. So we have to note that a managing director must always ensure, as a repetition, that the laws are complied in regard to the running of the business. So all applicable laws have been ensured. There is no breach, and a managing director is always required to keep track of the legal requirements. So when to come to the daily running of a business, it means that a managing director or managing directors have the responsibility to keep the books of accounts, to always update the books of accounts. The taxes have to always pay, to make sure that the business or the GmbH pays taxes. So this also brings us to a point that managing directors have always the responsibility to report or to give feedback to the shareholders about how the business is run through the books of accounts, through bookkeeping. So they have always to ensure that they initiate audits of a GmbH as timely as possible. And also we have to consider the fact that managing directors have the role of preparing and calling shareholders meeting, and also have to do that effectively without delay. They have also to act in good faith without any conflict of interest. So there are cases where managing director might be involved in cases where they are competing with GmbH for their personal reasons. So that is not required. It breaches the articles of association, and the shareholders may now raise a point of revoking the managing director's contract. So that means that the managing director has always to follow the shareholders' instructions. So he must not go against such instructions by the shareholders. Also, the managing director must be act with confidentiality, must not go against the confidentiality principle. That makes the end of the topic of managing directors in the GmbH. I thank you. Goodbye.